So I'd like to invite our first panel to come on up. Thank you very much for the introductions and welcomes. Our first panel is going to be on FASD-Informed Innovations in Court Practices, Judge's Perspective. And our moderators and committee members will be Peter Choate, a professor of social work from Calgary, and Judge Tony Wartnick, a retired King County Superior Court judge and FASD expert. So come on up.
Well, good morning. Bonjour. Buenos dias. Oki. Tanzi. Kaulo. Ahitskot. Kia ora. As we begin this, my use of probably poorly pronounced hello from a variety of languages, including the Salish language here, is a reminder that this is a conversation not just about the criminal justice system and the family courts and other courts, but it is about the lives of individuals intersecting with these institutions who come from a multitude of backgrounds. I'm very, very honored to be joined today by some very learned individuals. I'm sort of a piker up here, you know. They said they needed somebody who sounded like Kermit the Frog, and I fit. Starting at the far end there, we have Todd La Rochelle, who is a justice of the Alberta Court of Justice in Calgary. Todd and I have known each other a really long time. In fact, when I was first qualified as an expert witness in court, Todd was the lawyer who said, let's try and see if we can get this idiot qualified. And that was in front of our late colleague, the Honorable Justice Cook Stanhope. Todd is going to, has also been a counsel for child welfare and in the child welfare system. Next to Todd is a gentleman that I've had the pleasure of meeting on several occasions. And this is Michael Jeffrey. Michael is from, and I'm going to mispronounce this, Michael, so you may have to help me. Utqiagvik.
Place of honey and snowy owls.
Honey and snowy owls, okay. And Michael is a retired judge, but I think that part of what frames Michael so importantly in this conversation is how much attention that he has paid within the justice system of Alaska, and the influence that he's had on conversations of justice systems across North America. Sitting next to him is Larry Anderson, who is a justice of the Alberta Court of Justice. He was served as a criminal defense lawyer for 25 years in Edmonton. So he's two strikes against him. One is he's from Edmonton, and the second is he was a defense counsel. I don't care. So someone else here from Edmonton? Those of us in Calgary, just local humor for those of you who don't know, Calgary considers itself really the central part of Alberta, and all other cities are on the spokes. But Larry is particularly responsible. He's been on the bench for 18 years, but he's particularly responsible for the mental health court in Alberta, in Edmonton, in 2018. And then my fellow moderator, Tony Wartnick, I think is known to many, many of you. He served as a trial judge for 34 years, 9 years as a limited jurisdiction court judge, followed by almost 25 years in Kings County Superior Court, which is where we are, isn't it, Tony? Mm-hmm. Yes, so, okay. And he has also been the presiding judge of the Juvenile Court, the Family Law Court Chief Judge, and chaired the Family Law Department and Family Juvenile Committees. And Tony also brings substantial knowledge in the area of FASD and the courts. So please welcome our four distinguished. And we're going to start with some opening comments. And we're going to start with Larry, and then Michael, and then Todd. And then I think, Tony, you're going to manage questions, aren't you? He didn't know that till just now, by the way. So perhaps we might start by welcoming Larry.
Thanks. Over the next 10 minutes or so, I'll try to give you the perspective of a judge. In particular, the Adult Criminal Division. I was a criminal lawyer, as you heard, for 25 years before being appointed. I've sat in the criminal division. So my perspective that I'll try to share this morning comes from the perspective of sitting in the Adult Criminal Division court. And I think everybody in this room knows that persons with FASD are grossly overrepresented in the courts, the adult criminal divisions, and so I'm going to try to identify from the perspective of the judge, like what are the challenges that firstly people with FASD face when they are encountering the justice system, and conversely, what are the challenges to the justice system presented by, that multifaceted condition of FASD? And I've come to believe that FASD presents perhaps the biggest challenge to the adult criminal justice system in Canada, and I'm sure it is absolutely no different in the United States. And so I'm going to just try to identify what I see, at least, as the biggest challenges that hopefully we can collectively try to address, in whatever sphere we are in. I know that many of you are not going to be actually involved in the courtroom process itself, but everybody here can, within their own sphere of influence, make a difference in what the outcome of any given case may be for the person with FASD. And so I guess what I will say then, with respect to the segment of the criminal justice system that I'm going to address, when we think of the justice system, I think probably think mainly about the trials. You see TV shows every night on trials, and books are written about the trial process, etc. And obviously, the trial process is a big part of the justice system. But the reality is that, at least in our jurisdiction, and I suspect it's very similar across the board, but probably less than 5% of the cases that come before the court actually go to trial. And so that's why I'm not going to focus so much on trials. I'm going to focus on a couple of the other aspects of the court process, which includes the bail and the sentencing process. Because many, many times more individuals with FASD who encounter the justice system are going to be affected by the decisions of the court in those two contexts than the outcome of the trial. That's not to say, obviously, understanding FASD within the trial process is a very important thing. Confabulation and false confessions are something that are very problematic and need to be addressed. But that can be left for somebody else to address. I think probably to highlight how successful the courts have, or to reflect how successful the courts have been in terms of crafting conditions in the context of bail and in the context of community supervision, is reflected in the statistic, at least in Canada, where over 30%, and in some cases 40% of the crime, that is the criminal charges that are laid, are offenses against the administration of justice. Think about that. What that says is there is a massive gap between the expectations that are placed upon persons who come before the court and are dealt with by the court, and either the willingness or the ability of those who have to work with those conditions to meet them. And so we can't maybe do that much about what those individuals who choose not to follow the conditions that are imposed by a court. But what the court can do, and what the advocates can do in informing the court, is to pay more attention to the kinds of conditions and requirements that are imposed upon individuals in the context of bail and in context of probation orders or community, other kinds of supervision orders. Before I address sort of some of the obstacles that courts face in that context, I do want to make the point that we have come a long way, really, in the last 10 or 15 years within the justice system generally. There's a long way to go. But the mere fact that this many people are gathering today to address this topic from across the nation and across the continent speaks volumes. We would not have had a room full of people 15 years ago gathering to talk about the topics that we're here today. Secondly, at least in Canada, within the justice system and the case law coming out of the courts, when we first started paying attention to this, say 15 years ago, you would maybe find 10 reported cases where FASD was actually referred to in the case law. And some of the literature reflected that fact. Now, thousands and thousands of written decisions will include a reference to FASD. And all of the courts of appeal, at least in the province of Alberta, or in the country of Canada, have recognized FASD as a mitigating factor, which is huge. And those are the main the courts of appeal from the main jurisdictions. And so, that, I think, speaks volumes about the steps, that we've actually been successful in taking. But as I say, we've got so much further to go. And I just want to highlight what I see as sort of the four main challenges presented by the court when faced with individuals with FASD. And I guess my invitation to you is that we can all collectively, hopefully in our own way, try to address those kinds of challenges that we face. But the first is, just identifying the condition. People come into the system, and many people come into the system with FASD, but it is, as we all know, it's really hard to recognize. And so the greater the ability of courts to be made aware of the diagnosis of FASD, the better. And so those diagnoses and reports and whatnot that are prepared for it, as children, whether it's in preschool or within the school context or whatever, are gold and are really, really important in terms of actually then being able to identify the condition and inform the court of the person's challenges. But the ability to recognize the person with FASD, of course, is masked by all kinds of factors. Comorbidities, addictions are going to mask it. It's very difficult and time-consuming, and there's a lot of delay associated with the actual diagnoses. So, unfortunately, the reality is that a large number of people with FASD who are dealt with in the system are simply just, the court doesn't know. And that is a big problem. And I'll get to kind of the presumptions that are going to be applied in default and what the consequences of those are just in a second. But the second problem, I would just, I hope I might be going on a little bit too longer, but the second problem that I just wanted to I guess emphasize is the volumes of individuals coming into the justice system can be huge, especially in a larger urban center. In Edmonton, for example, a city of 1 million, we have 200 new cases in the criminal division every day, of whom, some portion of it, maybe 10%, maybe 5% of individuals are people with FASD. That's a large number of individuals coming into the intake process. And if any of you have ever been in the docket courts process, I'm sure it's the same almost everywhere. It's chaos sometimes. We're dealing with 200 people sometimes in a morning to try to triage, right? And so those who have a condition such as FASD fall through the cracks. Even the best-intentioned lawyers and best-intentioned judges in dealing in that kind of environment cannot do more than just scratch the surface and can't get, to the underlying problems. And of course, when you're dealing with individuals and making decisions quickly in that kind of a case, you get tired. And you get, and after maybe sitting in the court for 6 hours, you're not exactly at your sharpest. And that's when the heavy lifting starts, is later in the afternoon, when those who are perhaps the most in need of assistance and are then coming before the courts. And so what happens? Well, it's really easy. Let's just put this over. And so things churn, right? And those are the kinds of realities that unfortunately very much impact those with FASD. So, I guess what do we do about it? Well, we try to the extent we can to try to identify those kinds of people. And the reason we started the mental health court is so that you can take the people who really need that time and a slower process, take them out of that environment, put them into a courtroom, a mental health court, for example, where you can actually slow down the process. But that's always going to be a huge problem. And we have to recognize and be prepared to deal with it. Thirdly, we have an adversarial system in both Canada and the United States and any of the common law countries. That works really well when you're dealing with guilt and innocence. It's a good mechanism to find truth. Not so much when it comes to actually trying to find concrete solutions for people who are having difficulty coping. And lawyers and judges, because that's usually where they feel they come from, are hardwired to be adversarial, right? That's the way you approach. The idea of working collaboratively is foreign. And so it's an impediment, right, to constructive, collaborative solution finding. And so those norms have to be set aside. And then I think the last point I just want to make about what is really a problem that we often overlook are these deep-rooted presumptions that we have within the criminal law. Like, our entire justice system is predicated on the notion that we are rational beings, we know right from wrong, we are the product of our decisions. The first thing you learn in criminal law in law school, right, is the maximum, man intends the natural consequences of his actions, right? In other words, reasoned decision-making is going to be the presumed framework of analysis when trying to figure out what to do about somebody's misbehavior. Very deeply rooted in our system is the presumption that when people behave badly, they do it for malicious purposes. They do it as a conscious decision. It presupposes that people foresee the consequences of their actions. They're deemed to know the law, and they're deemed, right, to do that. So we, of course, have mechanisms within the law to recognize that not all people have the same level of comprehension and the ability to make rational decisions. But when it's the default position, and when decisions are being made in the absence of evidence to the contrary, those defaults are going to be resorted to. And so what happens then is that when courts are imposing conditions upon a person who perhaps isn't going to be able to follow those conditions, but the court doesn't know it, what's the consequence going to be? Right? It's going to be that there's there's a response by the court based upon an abstract construct, not the individual before the court, an abstract individual. And of course, the person may or may not be able to comply. So, those are what I see as really the big challenges. So to the extent that we can collectively and individually address the realities, those realities, we have to do everything that we can. I have a few comments I could make with respect to some of the solutions to those, but I will maybe pass the torch to the next judge, who will talk more about another area of the justice system.
Sure. We're going to welcome Michael. I'd like to just share one quick thing with you, Larry. This is soon to be published, as in sometime in the next 7 to 10 days, is a survey conducted by the Adult Learning Committee. It will be in the journal Disabilities, and it shows the degree of vulnerability to pressure in order to be liked in leading up to the commission of small crimes. Michael, would you join us, please?
Thank you. It's so amazing, I think, for all of us to be together again. And thank you to everybody that's making this possible. I'd just like to have a little show of hands, and that is, people raise your hand if you live and work in a community of, say, 10,000 or less. So there's a few of us. Yeah, that's a pretty good number. So basically, I want to talk about a few things in my own court, and then I want to talk about something that can be used in any size court. I grew up in Los Angeles. After education and so on, I took a job in legal services. Car crash when the tire blew out. Hospital. Went to India for almost 5 years. Came back, and within a month of arriving back in the States, I took a job in the remote town of Barrow, Alaska, now called Ukavik, to run a legal services office. After I'd been doing that about 5 years, they created a judgeship there. I didn't apply, not my big goal, but the local people, some Inupiat, very politically aware people, said, you need to apply, because if you don't, it's going to be somebody who doesn't know about us. And so I did, and ended up getting appointed, and ended up doing that for 32 years before the magic age of 70, when all judges in the state, in the Constitution, it says, are retired on their 70th birthday. So that happened many years ago, actually, but did I know anything about FASD? No, it was Anne Streiskooth, Dr. Anne Streiskooth. If you can imagine, she had just released one of the major documents, and they on FASD, and then she flew from all the way to Barrow to present at the a week-long FASD conference, and I closed the court. I was there, and she literally changed my life, because suddenly the light went on about how big this was, and how one of the problems was, that people, again, appeared like 90% of the people are completely normal, and yet they have these inward problems of understanding, which we've been talking about. So I suddenly realized, what am I going to do? And my first, I was thinking, well, it's the police, it's the all these other agencies, and then I realized the only one that I controlled was my own courtroom. And so one thing, it slowed it down, and was very conscious of no jargon. And then, like commonly used court forms, I made user-friendly. I took, in the back, there's a stack of them. It went through about 10 drafts with multiple advice, including retired judges from the Yukon, to the different things that are in there. But you'll notice, first of all, it's 4 pages long. It has a lot of white space. It has plain English. It has positive wording. And I even had a place where people initial by each of the conditions with the idea of focusing them on each one. Surprise, surprise, after my retirement, the court system is back with the one-pager, small print. Everything's on there, very efficient, and I really don't agree with it at all. But that's the biz that happens, and I can't control it. I'm retired, so there it is. I'm not surprised. So that that's what I did, and I want to talk a few minutes about something I used. This kind of things that I did, I get it. I was in a very small court. I was able to slow down the hearings, to the great aggravation of many of the attorneys. And there's various things that I could do, but if you're in an urban court with this huge caseload, and also you can't do this stuff. So what to do? Well, there's a doctrine of procedural fairness, and that can apply to any court. And I took a training on it. People from the National Judicial College came up, and it was after I retired, but it was great. And the research they have is that perceptions of fairness are largely based on understanding, so they understands the process, respect, that the person is treated with dignity and respect, voice, the person has a chance to be heard and considered by someone in a position of authority who really listened, and neutrality, the person thinks the authority figure is trustworthy, impartial, and trying to be fair. And the amazing research that they had is that if someone feels procedural fairness happened, there's been academic studies that show they even have less infractions inside the jail, and they have a successful, positive result. One other thing, and I very thinking ahead, brought my smartphone, but I forgot to start it these timers, so I'm not sure where we are.
2 minutes.
Huh? 2 minutes. Okay. Thank you. So I guess that's my pitch. If we all have to respond to the reality of the FASD issue that we're learning about, it's possible to change the laws. And Terry Tibbett is here, who's chair of the Alaska Center for FASD, which I'm on the board for. But she was a skilled advocate in the legislature, and an idea that I brought up years earlier, but basically is to have a statutory mitigating factor. And there was a powerful senator that, when Terry was in the office with him, with others, wanted to do something about FASD. And in the end, the statutory mitigating factor was what he supported. And weird experience for a judge to be involved testifying before committees and so on, which I had to get clearance through various channels, exactly what not to do, what to do, what I could do. But we were successful, and it passed unanimously and was not signed into the law, but the governor allowed it to become law. So it's currently on the books, the official mitigating factor for FASD and certain kind of felonies. And so that, this advocacy part is important too. And I really want to honor Terry's efforts. I also want to honor, of course, Dr. Streisluth, as I said, and Kay Kelly, who was the one that started me coming to the FASD conferences in Vancouver and was very instrumental in educating me, and so important these conferences are. So I guess that's where I'm going to stop in the interest of time. If people have any questions, either now or later, I'll be around, as my colleagues will be too. Thank you very much for your attention.
Thank you very much, Michael. So we're going to have Todd speak in a moment, but as a follow-up to Larry, one of the things, we're just publishing a study in which we looked at the question of what happens if a parent with FASD ends up coming before the court. And the reality is, if it reaches the point of trial, they may as well give up, because in the study that we've just completed, about 97% of cases where a parent comes before a child welfare court, they will not get the custody of their child back. And so that pretrial piece is so important, what goes on in the pretrial piece. The other piece that I think is relevant as we are about to listen to Todd, in the province of Alberta, and 76% of the children in care today are Indigenous. And so the importance of that as we listen to Todd is to consider that, therefore, what that means is we keep saying that FASD is most prominent in Indigenous children. What we might say is it's most prominent in the population that we've measured, which is Indigenous children in child welfare's care, because they're the majority population. And so that's another factor as we look to welcome Todd into this conversation.
Thanks. I really didn't want to stand because talking and thinking is enough. But I am here. I am both a judge who works in 3 courts that deal with FASD, and I'm also a parent. So that gives me a little bit of a unique perspective, and I'm going to take a bit of a sideline first. I'm going to start my timer. Thanks for reminding me. I'm going to take a little bit of a segue. Peter was the first one, probably 30 years ago, who said, "Todd, have you ever been checked for ADHD?" And I said, "No," and he said, "I think you should." And I was, and I am, and I believe it's a spectrum, and I'm out there pretty good on that spectrum. So hello to all you other ADHD individuals out there. I think all of us a little bit. The reason I mention that is to just make a point. Yesterday I went into the office only to get a tie to wear today. And last night when I got to my hotel and I went to check in and I said, "I'm here for 4 days," and they went, "You're not supposed to check in until tomorrow." ADHD can be a real inconvenience. Just ask my wife. But having a child with FASD, what a difference. And I noticed, I think it was last night or this morning, Stephen Greenspan, I'm not sure if he's here right now, but he released his notes and he said a big part of the problem is that judges and lawyers and so forth confuse ADHD with FASD. And I can only echo that as a parent, as someone who I kind of see it all, right? even though there's obviously some ADHD that goes along with FASD with some individuals, to my mind, the degree of the difficulty of the challenges faced is very different. So that said, as I said earlier, I see people in 3 different courts. In youth court, I see young offenders or accused. And we do get mental health assessments on them. I can order a mental health assessment at any stage of the process. Very few, in my experience, get ordered in order to determine capacity. Most get ordered for sentencing, which is a bit of a, that's too bad. But the assessments that I see for sentencing, in my experience, are very, very good. The ones in Calgary, they are unique to each individual young offender, but they do also have a number of things that they like to hit, and I mentioned those in my notes. First of all, judicial recommendations. These young people need someone to help guide them through that whole process. Community supports, therapeutic supports, and finally medical supports. And then along with those areas, assistance with routines, communication, decision-making, and sensory and regulation strategies. And so that's sort of a general overview of the reports. And like I say, they're terrific. They really help as a judge, because in the youth system, a little different from the adult system in Canada at least, we are all about rehabilitation and reintegration into the community, not so much deterrence and punishment, so to speak. In fact, not punishment. The problem with those assessments, the only problem with those assessments, to my mind, they come a little too late, okay? The child or the young person has already, if they're pleading guilty, committed the crime. And something that occurred to me, and Peter and I talked about, and others at a dinner we had not too long ago, was for all of us, I mean, I'm suspecting that most of us haven't had a lot of trouble with the law. Most of us haven't been arrested. Most of us haven't been arraigned, taken to court. So there's a little bit of a mystique there. I don't want to call it a fear, but there's certainly a respect, right? We don't want to go through that process. And I find with the young people, and I don't want to say particular the young people with disabilities or delays, but once they've had that happen to them, once they've been arrested, gone through it all, been released, they kind of go, hey, that wasn't that bad, right? I'm back home, and I got to do what I did. It'd be nice if we could help those kids before they reach that stage, right? And that sort of goes to the second area that I sit in, and that's child welfare. As Peter said, and I'm sorry to hear that statistic, the 97%.
76.
Sorry?
76%.
76. Oh, I'm sorry. I thought it.
Yep.
Okay.
It's 93 in Manitoba.
Okay, 76%. Still, in child welfare proceedings, it's much more of a mishmash, if that's a word. You know, we get, hopefully child welfare and the parents can work together, come up with some accommodations, come up with some plans, and they're able to work together to keep these kids in their home with their parents, which is what we strive for. That's what our legislation says we have to try to achieve, if at all possible. And I'm speaking on another panel this afternoon, and we're going to go into that a little more deeply. It's a bit of a mishmash because once you get into guardianship trials, and really those are the trials, temporary guardianship and permanent guardianship in Alberta. Those are the trials. I've got one right now that's next week. I'm going to go into my 23rd, 24th, and 25th day on them. That doesn't happen very often, thankfully, but they can be quite engaging. The problem is sometimes you get assessments on the parents, okay? And sometimes those assessments may say this parent has fetal alcohol syndrome, or they have certain disabilities, and with a little bit of experience, I kind of sit back and I think to myself, boy, I wish they would have checked for that. But I can't offer evidence, right? A judge can't offer evidence in a trial. I can't tell them what I think. Really, I can only go on the evidence before me, unless it's a well enough known fact that I can say take judicial notice of it. So that's a bit of a problem. The bigger problem is the kids are often not assessed, okay? And so what you get is you get two different, or if they are assessed, you get the assessment saying, well, these kids may have some real difficulties, some real disabilities and so forth, delays. And sort of in a best case scenario, you're left with one assessor for the parents looking at the report of the other assessor for the child and saying, well, I think that child, they're going to need, the phrase that is used in Alberta, one of our colleagues came up with it, is they're going to need a super parent. And these folks just don't meet the criteria for super parents, so they're not going to be able to do it. And I think often that could be too bad, because if we were able to work together collaboratively in this, people with parents with FASD may be able to be given the right supports that they can parent these children. But oftentimes you have one expert saying they can't do it based on what I've heard about the child. And so that's a bit of, in my experience or in my belief, that's a little bit of a shortfall. I wish we could try and work a little bit more collaboratively so we can say, yes, these parents can do it under certain circumstances. And that's certainly what I think most of us are striving for. And the final area that I sit in is family court, and I can just tell you, forget it. As far as FASD, as far as trying to help these families, you're not going to see an FASD assessment in family court. You just won't. Unless there's been child welfare involvement, unless they've commissioned a report. Most of the families that I deal with in my court cannot afford those types of assessments. They're expensive. I can tell you that my child did not have a formal assessment. I had a very well-known pediatrician in Calgary say to me, look, looking at the sentinel features and hearing about all the behaviors, you don't have to go get that assessment. I can tell you right now. I should have done it anyway, obviously, because I would have gotten a lot of good recommendations out of it. But even being a lawyer with child welfare, the cost was it was something to think about. A lot of these families just don't have that ability, and unless they're involved with child welfare, it's just not going to happen. And so, you're dealing with parents who might have disabilities that you're not going to be aware of. You're just going to hear the anecdotal, the bad evidence, right? You're going to hear, well, they didn't do this, or they didn't do that, and you don't hear why, because you don't have an assessment. And then when you hear about the kids, you're going to hear, well, they've got behavior problems, they're suffering some real deficits in school and everything else. But again, you're just guessing because you don't have the assessment. So in my experience, family laws, the family court is just a mess as far as this issue is concerned. I think King's Bench, which is the court that's superior to ours, quite honestly, you get people who economically generally do better in that court, and those assessments might be available. So, although I see a lot of good news, I see good things happen. In fact, you're all here, we're all here, is very good news. And obviously I'm someone who has a real heart in the game. There's still work to be done. Lots of work to be done. And hopefully, with all of you good folks and others like you, we'll just keep evolving and we'll get there. So, thank you very much.
Okay, we are now at our Q&A part of the program, and if you have any a question, raise your hand. I'll try and see you out there in the back. Yeah, let's go to a mic if we have them. I think that's the most effective way. Okay.
Hi, my name is Julene Zietza, and I'm from Colorado Springs, Colorado, and I'm here with my son, Gianfranco Zietza, over here. And I have a question. Peter, could you clarify that new study that's coming out? Are you talking about parents with an FASD, or are you talking about biological parents who have a child with an FASD? And could you clarify the numbers, because I too was concerned. I heard a 97% and then a 76, and I couldn't get that clarified.
So, I guess this one's not on. So the study that we did in Canada was just on cases in which a parent with FASD is before a child protection court. And so in those cases, so they don't come up actually as often as we think, because information would suggest that these are often settled before they come to trial. So a very small number come to trial, and of those that come to trial, over 90% will not be able to keep their child.
And does anybody on the panel have experience with statistics over birth parents? I am a birth mother of my son, Gianfranco Zietza, and so I'm just wondering what the statistics are for birth parents.
That data does not exist in Canada. I can tell you that in another project which we're in, Canada had birth alerts taking place until a couple of years ago, and the initial data we see is that fetal spectrum disorder was a significant representation in those birth alerts, but there is no published data I'm aware of related to apprehension of children at the time of birth with a parent with FASD.
Thank you.
Okay. Over to my left here.
Hi, I'm Ron Hansen. I'm from Chico, California. I am pleased to see and hear about the enlightened courtrooms that your colleagues have described. However, I'm curious about the tension that frequently exists between a society which is not so enlightened and the tension between accountability, therefore, and compassion and rehabilitation. I'm wondering how, if any one of you would like to address that tension and how you deal with that. Thank you.
First, you'll notice I don't have a tie today either, so that tension I think is always going to exist, but what's I think the key to that is being able to articulate the reasons why a court is doing what they're doing and what has gone into the decision process. And in Canada, the Supreme Court has made it clear that judges are expected to give reasons. And so it all has to do with communication, I think. And if it is well communicated, I think the public will, generally understand why the court has gone down a route, different than what the armchair critic without knowledge would have assumed. So to me, it's just a question of communication.
I might just add a little piece to this from my experience, and there's quite a bit of literature on this. It can be a real problem because lawyers tend to try and resist raising issues that they feel are going to have a negative impact with regard to individuals with fetal alcohol.
Hi, I'm Ron Densmore. I do adult FASD assessments, and I have seen quite a large number. I don't know, maybe in my clinic it might be 20% of them that have quite profound problems with estimation of quantities. And I'll get at that by asking them how far a distance is. And they'll, maybe it's I don't know, from Seattle to Vancouver, they do that trip all the time. And they'll say 3 hours. Yeah, but what's the distance? They have no idea how to estimate it. So then I'll say to them, okay, what's closer? Is it closer to 200 miles or closer to 20,000 miles? And they'll often say something really whinny like 20,000 miles. Like they really don't get amounts. And so I'm really interested in this group, if you've ever seen anything written about how if somebody has, at a brain level, difficulties with estimating amounts, how does that square with the criminal justice system? Because that's based on this much penalty for this much crime, and this much penalty for that much crime, which is an amount thing. And the idea is the big one keeps you in check. And if you don't have the hardware for amounts, probably, like, I'm really interested if there's a study, but if there isn't, how would we make sense of that when we're interacting with the legal system? Thanks.
Anyone want to comment?
Can take a stab at it, I guess.
Yep.
I mean, in a way, that's really just addressing how effective or meaningful is specific deterrence in the calculation of imposing a sentence. And I think it's, because the whole premise of specific deterrence is that, if you impose a sentence that is unpalatable, then the next time it will deter that person from engaging in that same kind of behavior in the future. But I think it's very clear that specific deterrence is virtually meaningless and pointless when it comes to the effectiveness of a sentence. And also, there is case law. I know, for example, in Canada, there's a number of appellate decisions which actually recognize that. That said, there will then also, though, be a push by the Crown or by the prosecution to say, well, maybe specific deterrence isn't a factor here, but what about general deterrence? Other people of like mind have to know that there's going to be consequences, etc., and that's still something that has to be factored in. But generally speaking, one of the main reasons why not only does FASD affect the moral culpability, but also the fact that specific deterrence is not going to be effective is something that can quite properly be considered.
Can I jump in just for a sec on the youth side of things? We really don't want to put young offenders with mental issues in jail, okay? We're putting them in with kids who have usually committed some severe acts of violence, and as we know, the kids that we deal with are often easily led. They're vulnerable to these influences, so we don't want to put them together, right? So in youth court, it's more a matter of, look, what can we do to help this young person without, making it a longer sentence, without having them longer in jail, et cetera, et cetera. And I meant to mention earlier, and I forgot, but I'll tell you now because I think it's great. An anecdote, one of the judges, I had asked for some stories about this issue, and one of the judges, George, said to me, the most effective conditions on release that he had instituted with the young person with FASD was don't hit anybody and don't take their stuff. And that's what he said to him in court. Normally we go through all these terms, you shall not, don't hit anybody and don't take their stuff. And they said, and come back every week or two to check in. And that kid did, and they didn't hit anybody, and they didn't take anybody's stuff.
Yeah, when I got the first FAS, or pre-FASD, because we didn't have the umbrella back in the early 90s, I got the first case involving FAE in juvenile court. And one of the things I didn't learn about in that during that proceeding was this type of issue. It wasn't until after I retired from this court and became the legal director for FASD Experts, which was the first multidisciplinary organized assessment team in the United States. And Dr. Adler, Rich Adler, who will be speaking during the main conference, subjected me to the Vineland. And then I really, it hit home what a lot of the problems are with individuals with FASD being able to give accurate information, whether it be to a question such as what was posed a few minutes ago, or keeping track of calendared things and that type of thing. Okay, let's go back over here.
Hi, so my name is Nicole Leblanc. I'm a pediatrician. I'm also a deputy registrar for the College of Physicians and Surgeons of New Brunswick, so I'm from Atlantic Canada. So I'm in the regulatory body field. I'm also the founder and medical director for the New Brunswick FASD Center of Excellence. And as we're talking here today, I'm trying to understand better because we're still talking a lot in silos. And we know that FASD is a beautifully complex, there's a lot of complexity. We have challenges with access. So I'm hearing you say you have challenges with access. We have challenges with access to diagnosis. We're still very diagnosis oriented, right? So we need a diagnosis. We need to know, are they competent? Are they not competent? So in a research world, I'm just trying to eliminate barriers and trying to think from a judicial component. Is there any research, or could there be research, in trying to be more inclusive and co-constructing some of these plans, having the medical expert there, having the expert, the individuals with lived experience participate, in order to take away those hats of this is my expertise, that's your expertise, but really more like coming together as a community with somebody having challenges, having needs, and how can we better meet the needs in order for them to be better integrated within their community. So just trying to understand from a research perspective, is there any research, are there any programs that are out there that have shown success where we can actually all come together and co-construct these plans? That's my question.
Well, with respect to Child Welfare Corps, I'm just going to talk about Child Welfare Corps for a second, but it goes to the other courts as well. The child welfare workers will usually have case conferences, lots of case conferences during the course of a proceeding, and all the experts will get together and talk there, and these things can be discussed and hopefully information shared and becomes more productive. The problem is when it comes in front of the judge, as I think it was Larry who said earlier, then we get into the adversarial system. So now we have, and it shouldn't be an adversarial system in child welfare, it should be a collaborative system, but it's adversarial. So you've got the parents' lawyers fighting the director's lawyer, and questions get asked, and well, you didn't assess those children, so how can you arrive at that opinion? And it all falls apart. So to me, in child welfare court, if we can get away from the adversarial and try and get into a bit of a more collaborative system, I think that would help. If that answers your question.
And the key factor is like understanding, because if we're all there to try and understand better, it seems that we would be getting to solutions probably better.
If I can, it is working. If I can just add, in terms of the adult system and the criminal side of things, the whole rationale for the development of the mental health court initiative, at least in Edmonton, was in fact to address that very problem of everybody working in silos. And so the whole philosophy in developing the court was to adopt a collaborative approach to problem solving and to bringing the professionals and those with the most knowledge closer to the courtroom. So we actually have medical professionals right in the courtroom, so we can access medical information more quickly and things like that. And generally, encouraging the collaboration of as many parties as possible, including parents and the like. So, which is kind of antithetical to the traditional adversarial system. And so, there are hiccups along the way, but there's no question that both in the context of bail and in the context of dispositions, it's really the only way to go.
Yeah. We're going to have to bring this to a close in order to stay on schedule, but I might just make one comment about this. When I went to law school, we didn't have clinical courses such as on negotiations. When my daughter went to law school, she did take a negotiation course, and that has eliminated some of the adversarial interaction, at least between the attorneys. Okay, we'll break now and enjoy your coffee or whatever.